Hi, this is Virginia Hihon Camanyo with Jackson Landreth and Coles PC. Yesterday, we walked you through getting started with a family-based visa petition. Today, let's take a look at a couple of commonly asked questions. First up, can my family member come to the U.S. to live with me while the visa petition is still pending? This may be possible, however, you cannot come to live in the U.S. permanently with no other visa. If you are qualified for a different visa, you can stay in the U.S. while the family petition is pending. One such example would be if the immigrant relative wants to come study in the U.S., then they can get an F1 student visa and be in the U.S. studying while waiting for the family petition to be approved. Be careful of the J student visa, however, as usually J visas require that the immigrant return to their own country for 2 years after the J visa is finished. Another instance where it is possible for the relative to stay in the U.S. is if an employer sponsors them for a job and petitions for them to get a temporary work visa. On a tourist visa, however, the immigrant's family member would only be able to stay in the U.S. for 6 months at a time on a B2 visa or 3 months at a time on an ESTA visa, and only a total of 6 months per year without accruing unlawful status. They would have to go back to their country after their time was up in the US and wait for other time to come back in. They would also have to go back to their own country for consular processing. They would not be able to adjust their application in the US with an I-485 unless they were already here and could prove a change of circumstance in order to concurrently file the I-485. Another question people often ask is, can I get an appeal for a denial of my petition or application of a family-based visa? It is possible to appeal a denial, but it is usually not the most expedient way to get a family visa. If circumstances have changed since your original application was filed, or if your original application was not very thorough, you would be better advised to refile a new application. Appealing can actually take longer and cost you more in court and attorney fees than reapplying, even though you do have to pay the USCIS fee again with a new application. In addition, USCIS gives you several chances to redo your application before they deny it. If they think documents or information is missing, they will send a request for evidence, an RFE, or they will send an intent to deny, an ITD. In each of those cases, you are allowed extra time to correct your application and add more documents. So getting to an actual appeal is very rare. We hope that this short video series has been helpful. This process doesn't have to be as overwhelming as it may seem, and an immigration attorney can be a great ally to streamline the process and ensure your case is processed efficiently. For more information on applying for family-based visas in the U.S., an initial consultation is your best step. Get the information and legal answers you are seeking by calling us at 817-226-1100 today.